a WIPO arbitration of a biotech pharma dispute. A French biotech company, holder of several process patents for the extraction and purification of a compound with medical use, entered into a license and development agreement with a large pharmaceutical company. The pharmaceutical company had considerable expertise in the medical application of the substance related to the patents held by the biotech company. The parties included in their contract a clause stating that all disputes arising out of their agreement would be resolved by a sole arbitrator under the WIPO arbitration rules. Several years after the signing of the agreement, the biotech company terminated the contract, alleging that the pharmaceutical company had deliberately delayed the development of the biotech compound. The biotech company filed a request for arbitration claiming substantial damage. What is arbitration award? An arbitration award or arbitral award is a determination on the merits by an arbitration tribunal in an arbitration and is analogous to a judgment in a court of law. It is referred to as an award even where all of the claimant's claims fail and thus no money needs to be paid by either party, or the award is of a non-monetary nature. What is the WIPO Arbitration and Mediation Center? The WIPO Arbitration and Mediation Center was established in 1994 and is an administrative unit of the International Bureau of the World Intellectual Property Organization WIPO in Geneva, Switzerland. Its purpose is to offer arbitration and mediation service for the resolution of commercial disputes between private parties involving intellectual property. The dispute resolution procedures offered by the Center, which lends themselves also to other types of commercial disputes, constitute alternative to court litigation. The Center is international, independent, and nature and is assisted in its operation by advisory bodies composed of external experts in international dispute resolution and in intellectual property.
The Center proposed a number of candidates with considerable expertise of biotech pharma disputes, one of whom was chosen by the parties. Having received the parties' writing submission, the arbitrator held a 3-day hearing in Geneva, Switzerland, for the examination of which this not only served for the presentation of evidence but also allowed of parties to re-establish a dialogue. In the course of the hearing, the arbitrator began to think that the biotech company was now unable to terminate the contract and that it would be in the interest of the parties to continue to cooperative towards the development of the biotech compound. Which dispute resolution producer does the Center offer? Mediation, a non-binding producer in which a neutral intermediary, the mediator, assists the parties in reaching a mutually satisfactory, agreed settlement of the dispute. Arbitration, a producer in which the dispute is submission to one or several arbitrators who make a binding decision on award on the dispute. Expected arbitration, a form of arbitration in which the produce is conducted and the award is rendered a short time at reduced costs. Mediation followed in the absence of settlement by arbitration. A producer which convenes mediation and where the dispute is not settled through the mediation within a period of time agreed by the parties. Arbitration. Types of arbitration. Judicial arbitration is usually not arbitration at all, but merely a court process which refers itself as arbitration, such as small claim arbitration before the country's court in the United Kingdom. Online arbitration is a form of arbitration that occurs exclusively online. There is currently an assumption that online arbitration is admitted under the New York Convention and E-commerce Directive, but this has not been legally verified. Since arbitration is based on a contractual agreement between the parties, an online process without regularity framework might generate a significant number of change from consumers of the weaker part of due process cannot be assured. How law arbitration or brackets arbitration is an arbitration wherein the part to dispute agreed advance the limits with which the arbitral tribunal must render awards. It is only generally useful where legally is no dispute and the only issue between the parties is the amount of compensation.
Binding arbitration is a form of arbitration where the decision by the arbitrator is legally binding and enforceable, similar to a court order. Non-binding arbitration is a process which is conducted as if it were a conventional arbitration, except that the award is issued by the tribunal is not binding on the parties, and they retain their right to bring a claim before the courts or other arbitration tribunal. The award is in the form of an independent assessment of the merits of the case, designated to facilitate an out-of-court settlement. State law may automatically make a non-binding arbitration binding if, for example, the non-binding arbitration is court-ordered and no party requests a trial de novo, as if the arbitration had not been held. 42. Pendulum arbitration refers to a determination in industrial disputes where an arbitrator has to resolve a claim between a trade union and management by making a determination of which of the two sides has the more reasonable position. The arbitrator must choose only between the two options and cannot split the difference or select an alternative position. It was initiated in Chile in 1979. This form of arbitration has been increasingly seen in resolving international tax disputes, especially in the context of deciding on the transfer pricing margins. This form of arbitration is also known particularly in the United States as baseball arbitration. It takes its place from a practice which arose in relation to salary arbitration in Major League Baseball. Night baseball arbitration is a variation of baseball arbitration, where the figures are not revealed to the arbitration tribunal. The arbitrator will determine the quantum of the claim in the usual way, and the parties agree to accept and be bound by the figure which is closest to the tribunal's award. Such form of last offer arbitration can also be combined with mediation to create medola, hybrid process mediation by last offer arbitration. So this is mediation followed by last offer arbitration, medola. How are the HIP dispute resolution procedures conducted? Each of the ADR procedures offered by the sender is conducted pursuant to rules. The HIPO mediation rules, the HIPPO arbitration rules, and the HIPPO expedited arbitration rules. These rules, which exist in several languages, incorporate the latest development in the area of dispute resolution and can be used in any legal system in the world.
On the last day of the hearing, the parties accept the arbitrator's suggestion that they should hold a private meeting. As a result of that meeting, the parties agreed to settle their dispute and continue to cooperate toward the development and commercialization of the biotech compound.